with us today.
Thank you.
We do have an incumbent in this race. Ken is the incumbent. However, we are very chivalrous here at AAG, so the first question is going to go to, first opportunity to speak, I should say, will go to Rena. Rena, if you could just give us a brief introduction to yourself, maybe a minute or so, and in that, tell us why you've decided to run for this particular race at this particular time.
Okay, very good. I've been a family law attorney since 1989, having been licensed in Nevada in 1990. I came out from Oklahoma, and I've practiced family law since that time. So for 24 years, I've been a family law attorney. I've also done some other things such as labor. I represented the Police Protective Association, and I did some general business litigation. But predominantly, I've done family law my entire career. After 24 years, I think with my level of experience that I would be a great asset to the bench. I am an AV rated attorney, which is the highest rating an attorney can achieve. That is an anonymous survey that is done with the judges and my peers. And I don't know who's voting on that, but they do turn that into Martindale. And I'm AV rated, that's the highest credentials as far as legal knowledge and ethics. I'm also a family law specialist. There are 32 in the entire state. I took an exam that's administered by the Nevada State Bar, but I also had to be nominated by judges and attorneys to even take the exam. So I passed that exam a couple of years ago because I am very dedicated to the practice of family law, and I wanted to step up my practice and become a specialist. So that's what I've been doing. I've also been a pro tem judge for several years. I sit when a judge cannot sit, and that has been for abuse and neglect for Diane Steele. I've sat for her. I'm a hearing master. I'm a settlement hearing master. I promote settlement. I was an arbitrator and a chair for the State Bar Fee Dispute Committee for 13 years because I really believe in alternative dispute resolution. I believe in settlement and mediation, and I do serve as a mediator. I spend quite a lot of time with community service, pro bono service. I represent Holocaust survivors for their applications to the German government, and I've received pro bono awards for the number of hours that I've contributed to pro bono service for several years now. And I think it's time that I step up and that I try to restore the public's confidence in family court, because I think that's been somewhat lost over the last few years. And that's why I'm running in Department J, and I believe I would be a great asset to the judicial bench in family court.
Thank you. Romeo.
Well, I've been here in Las Vegas since 2003, originally from South Texas, where I grew up. I come from a family with a background in small business. I had a grandfather on my mother's side who owned a produce business. Grandfather on my father's side owned a gasoline station back when we had gasoline stations. I had my father owned his own construction company, so when it came time to practice law, I opened up my own office. So I've had my own business for about 16 years now, and in that time we moved here to Las Vegas, and we've been here for about 11 years now. In that time I got married, just recently had my 10th year anniversary. I've got a 6 and an 8-year-old, 6-year-old boy and 8-year-old daughter. And I think that one of the things I'm most proud of, and especially has come out in this campaign, is that I've been able to help my clients through their issues. You know, when people talk about family law being a specialty, it is a specialty, but it's a very broad specialty. I like to think of it as I have to deal with just about every situation that a family can go through. It's not just about their divorce or custody case. Sometimes these families have gotten a DUI, there's been domestic violence, there's been a car accident, they've gotten in trouble or need a guardianship or a probate. I've been able to not only grow my business, but assist my clients in the issues that they meet. And that's what I think is important about having a judge on the bench who not only understands the laws and the rules as they apply to family law, but about the issues that families face as they grow. I've always tried to be the open door to the community that they can call. I tell people constantly, look, if you don't call me, and if I don't know the answer, I'll find you somebody who does. and I've made my living on that. I've grown my business on that practice of giving a free consultation, have an open door policy with people who call and just ask the questions. And I think that's important because I've been helpful to the community. I've been helpful to my friends and to my clients' friends. I think that's what we should be doing as attorneys, because we are given this great obligation, this great education, this great ability and position in the community. And I think we should be helping people. And that's what I'm about. And the reason I'm running for court is because after 16 years of practice, I believe that we need to put family back in family court, understand that families need to be the center, and we can't just cookie cutter families. We've got to wrap the law around the families, not the family around the law. And I think that's where we can do better in Department J.
Okay. My name's Ken Pollock. I'm currently the incumbent in Department J. I was elected in 2008, started January 2009. Backing up a little bit, I obtained my bachelor's degree from the University of California, San Diego, law degree from the University of San Diego. While I was in law school, I served as a certified legal intern representing juveniles in juvenile delinquency matters. When I passed the bar, I started practicing in our sister state, had my own practice there, and also represented generally men, but both parties in child support and paternity actions. Handled probably about 300, 400 of those cases. And in about 1994, I think it was, myself and a couple of other attorneys recognized that there was an access to justice problem in the Los Angeles Superior Court with these paternity cases, and formed an organization called the Family Law Indigent Paternity Panel, where we represented these individuals either as court-appointed attorneys or pro bono or reduced fee. When I moved to Nevada, I left that organization, but it continued to exist, and to my understanding still exists today, representing low-income individuals. I've represented individuals and corporations in probably every area of law other than bankruptcy and probate, and I can't even exclude probate anymore because since I think it was 2011, maybe 2012, I've been the alternate probate judge for the 8th Judicial District Court. There's 2 judges that handle probate, so I handle probate now as a judge. As in my legal practice, before taking the bench, I was an arbitrator for over 11 years, and I also served as an alternate municipal court judge for the city of Las Vegas. So even before becoming elected, I had extensive judicial experience, which has served me very well as an elected district court judge. I've also been committed to community service. I currently serve on board of trustees for both Children's Speedway Charities and for the Clark County Law Library. In 1994, after the Northridge earthquake, I was also one of the founders of an organization to represent and assist policyholders to recover from the Northridge earthquake, and I was chair of the Farmers Policyholders Group, assisting a couple of thousand families dealing with the insurance company to get their lives and their families rebuilt. I'm very proud of being able to help these people, and as the chairperson, I was unpaid. It was a pro bono service helping to rebuild the community. So since 2009, I've been serving the people of Clark County as their elected judge in Department J.
And I usually, with an incumbent, I usually say this to the other individuals, but I'll say it to start right out the gate. I will say it now. I have no active cases in front of Judge Pollock, just full disclosure. Let me take that back. I have one case that's currently filed in his department, but we're getting the other side to sign off. It's going to be a summary dispo, so there'll be nothing substantive per se. But I have no substantive cases or really any active cases in front of him. Again, just to promote full disclosure for both of you, and you don't even know that other case is on the radar, so it's news to you as well.
I probably have about 22,000 cases.
Yeah, so all that having been said, dovetailing back with full disclosure, and we'll start with Ken and rotate back around. There has been some uproar as of late regarding political contributions to sitting judges by litigants and the appearance of impropriety that may exist therein. what ideas do you have, and again, I'll start with Ken and go across, what ideas do you have to try and minimize the appearance of impropriety, not only in those situations, but across the board, be it through disclosure or other means, such that everyone who appears before you, assuming you're re-elected or elected to the position, that everyone feels that they got the same fair shake?
Okay, well, to start with, I don't solicit funds from attorneys or litigants. And that makes me a little bit different than most candidates. I also keep up on the bench a notebook that has all my campaign disclosures. While I don't solicit occasionally, during the election campaigns I do get some contributions that are voluntary contributions, and I obviously report them as required by the law, and I go one step further of having those disclosures available. Anyone that wants to see it, I have no problem showing it.
Okay. And what ideas do you have to try and mitigate any appearance of impropriety, such that the parties, the litigants themselves, feel that they have gotten a fair shake beyond the disclosures from a financial perspective?
Well, I mean, obviously as a judge you have to disclose anything relevant that could lead to the appearance of impropriety. So just like, and it's kind of a strange analogy, but in real estate, disclosure, 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 anything that might lead someone to question your impartiality, disclose it.
Romeo.
I think we should change the rule. I mean, if you have an active case in front of a judge, you simply should not be able to give money to that judge. I think that it at least doesn't pass the smell test. I think that that if a judge raises money from a litigant, I think it should be returned. I think at the very least it should be disclosed to all the parties, and then the parties should decide what should happen to that case. I would hate to think that would have to be transferred because of that, because that would be, I think that would be very detrimental to the case. But I think that we should change the rule. I think we should not allow litigants. Now, lawyers do it all the time. We as lawyers, as practitioners, get phone calls all the time about requiring contributions or asking for contributions.
Requiring is probably not the right term to
use. I changed that, right?
Soliciting.
Right. We'll soften that up.
Yeah.
But no, and you even have other attorneys who call on behalf of judges to ask it, make the ask for. So, and sometimes judges may not know where that money's coming from right away, but that's why I think we need to change that rule. So that would be my.
Well, you said change the rule for the litigants. Are you including attorneys as well?
No, I don't think we can include attorneys.
Okay.
Attorneys are a little different, and that's a whole other issue as to the attorney and judge relationship. But as far as a litigant who actually has a case in front of them, I think it just doesn't pass the smell test.
And Rena.
Thank you. I think it would be highly inappropriate for a sitting judge to take money from a litigant that had an active case in front of him or her, and definitely accepting that would be unethical in my mind. If the family law bar wants to support you with a contribution, to me, I think they have a catch-22 situation, and I would prefer that judges are appointed myself, because this whole process of campaigning to me seems non-judicial in and of itself. I'm not comfortable with the whole process. I've never campaigned for anything before. But I think that these family lawyers, they're hedging their bets, and they're contributing probably to everybody across the board to see, they don't want to become disfavored by anybody. I could care less if they contribute or they don't contribute. It makes no difference to me, because my ethics and my standards will not be compromised for anybody. So if they think that they're going to win favor with me by contributing, I'll return the monies. I don't care to have it. But I'm also not self-funded. I don't have a trust fund where I can pay for all of my own campaign signs and things like that. So I do rely upon the generosity of people, not current clients, if they are past clients and I'm no longer representing them and they want to contribute, or if I have friendships with attorneys. I've been here 24 years, I know a lot of people, and if their vote of confidence is to help me pay for some campaign signs, I don't see anything unethical about that. But as a sitting judge, it's a totally different perspective, because you can't accept funds from someone who has an active case in front of you. That's just unethical. And if it's not an active case, I don't see a problem with it. Of course, you're going to put it on your report, and you're going to be filing that report. But again, I would not compromise my ethics for anybody. I haven't done it, and we have ethical dilemmas all along when we're attorneys. And to me, I'm not going to compromise my license, my good name, and my integrity to become biased on or prejudiced on anybody's part. I mean, it stops with me, so I wouldn't accept it.
Okay, thank you.
That's why we do this 100% free.
Yeah, much to our chagrin, we're not getting paid to do these interviews. It's strictly it's a labor of love. It is.
I thought I was the only one.
Well, it's all the hot air from all these attorneys in here. What do you expect?
I knew that was coming. That's why I didn't want to be the first one to raise that.
Can't help it. It's just a fact. One of the other areas of interest that we have, that we've been asking all the judges, all the judicial candidates, and we'll start with Rena and go back across, is this. Every 2 years, the RJ brings out its judicial performance evaluations. And there's a lot of criticism. Well, there's criticism regarding how the RJ handles them, and the information it contains. And Rena, and again, everyone will have an opportunity to answer. What ideas do you have to either A, improve upon how the RJ is presented with the information from which it derives its statistics, and B, how do you think it can be improved such that the general public has a better idea as to how judges rate amongst their fellow peers?
Repeat the questions again, please.
How can we make it a more, let me streamline it, how can we make the RJ's process a little more transparent, and B, accurate? Maybe that's the best way to put it. So that the public can have either a more appropriate or a more accurate, how can we make the evaluations more accurately reflect the realities of the individuals on the bench?
Well, the question assumes that the Review Journal survey is not accurate, right?
People have criticized its accuracy, yes.
Okay, I know they've criticized the accuracy. I see the Review Journal process as being beneficial because otherwise, how do attorneys anonymously give feedback to the judges? I think that the Review Journal should state that this survey was returned by however many attorneys, because you're only supposed to rate the judges you actually appear in front of. So if the RJ is sending it out to everyone in the bar, and obviously I'm not in front of a criminal judge, I'm not in front of the district court judges downtown, I'm only going to rate the family law judges, they should say how many attorneys actually returned the survey, saying that these many attorneys said that they practice in front of this judge, and this is how they rated the judge. I see it as beneficial for the attorneys because that's really the only way we can anonymously give a message to the judge. We practice in front of you, and these are the things that we would like to say to you if we could, but we can't. Can you improve in this area? Can you improve in this area and this area? And I think the judges should take heed and look at that report and say, maybe I can do better in these areas. As far as the RJ, I mean, they publish it for everyone to know. Honestly, I didn't participate in last year's survey because I missed the deadline. I was just too busy in my practice. But I think that they should definitely have the attorneys, however many, rated in each department. Say there's 200 judges or 200 attorneys that rated this one judge. They should say that that's how many did it. That's I think as transparent as you can be. You can't give the attorneys names because it's anonymous for a reason. You can't go up to a judge and be critical of them and still practice in front of them and expect them not to take issue with you, I think. I wish that were different, but I think it's a valuable tool, the RJ's survey in and of itself.
Okay. Romeo.
I'm not privy as to the methodology of the RJ. However, my reading of it, my understanding of it is that it's the attorneys who have been before certain judges are the ones who've answered the questions. And I think that it's a sample. it's as good as you're going to get with any kind of survey, whether it's they call you at the house or you actually do what we do, which is get online and answer the survey and make our comments. I think what's important to look at in the survey, in the RJ survey, is not necessarily the particular numbers, but the trends that you get out of the RJ survey. It's not necessarily that only 50 people or 800 people or 10,000 people answered out of a certain number. It's the trend that you're seeing, and the trends are more indicative of what the general family law population attorneys are thinking. I know that it is pretty indicative, and I'll tell you that I'm in family court just about every day, and I know I've been in front of every one of the family court judges, and I know where the good judges are and where we could use improvement, and they are pretty consistent with what's coming up in the RJ. So if you look at the trends and what they're talking about in the survey of the RJ, I think that you get the right feel for what's going on there with the number of attorneys who have answered. I did answer because I think it's important, because I am in front of all of those family court judges every day. There are people in the general public who are only there for maybe a couple of months in their case, and they don't know what the judges are like day in, day out. They don't know what the judges do with a paternity case versus a custody case versus a divorce. It's important that you have the attorneys who are actually there, who've had those different issues before the different judges, to be able to comment and let the public know this is what we believe.
Okay.
Being the only one in the room that has been subjected to the survey, I guess I have an interesting view on it. And to start with, it's a flawed survey, but it's the best thing that we got, unfortunately. The Supreme Court, I think it was about 2006, 2007, proposed a similar type survey, but expanding it to respondents both from, or all from the attorneys, court staff, litigants, anyone, the justice partners, anyone that has contact with the courts. Unfortunately, that project never went anywhere, because in terms of accuracy, that certainly would make it a better survey, because as it stands right now, the attorneys have a vested interest. And I can talk about my case, there are certain things that I do that are good for the community, good for the public, good for the taxpayers, not good for the lawyers. I'm not very generous with attorney fees. There's a dispute, and eventually, hopefully, the Supreme Court answers whether attorneys can adjudicate liens against their clients, which is basically getting judgments against their clients without the necessity of actually suing them. Something that no other creditor in this state can do. I've said, no, you can't do it. You have to follow the same rules that any other creditor has to do. Obviously, attorneys don't like that. It's reflected in the survey. I also ran in 2008 saying that the family division is broken. There's parts that need to be fixed. And I've been moving and working to change that since 2008. The attorneys that have a vested interest in the old system obviously aren't going to be happy about seeing that change. So there are a lot of things that go into the survey that affect the results. The more that you're an agent of change, generally the less popular you are. I think another thing to look at is a judge's appellate record. How many times has the Supreme Court disagreed with a judge? In my case, I've had over 6,200 motions. I am assigned roughly 100 to 125 cases a month. So there's a very large pool of decisions that I've made. When you look at the appellate side, there are very few appeals, and even fewer of them actually succeed. That's a far better reflection of how the judge is applying the law and the appropriateness of their rulings than what a very small subset of the attorneys who may not be happy with your rulings, how it affects their business bottom line. And I could say, since Ms. Hughes mentioned she would like to know how many attorneys actually respond, there were, I think, about 4,800 attorneys that were invited to participate in the survey. In my particular race, 115 actually responded. So it is such a small sample. And then when you break it down even further into the percentages that say should be retained or shouldn't be retained, it's less than 30 lawyers different between should retain and shouldn't retain. That is such a small sample. It's not particularly helpful, but like I said, it's the best that we have right now. The other thing is, in terms of transparency, the fact that it's anonymous creates problems because there's no way to verify that these lawyers have even appeared before the judge. At a minimum, they should disclose who responded to that attorney, or the RJ, through their investigative reporters, should go back and validate that each of these respondents actually did appear before that judge, something that does not currently happen.
Okay. You had mentioned that when you ran in 2008, I think you had said that there are things with the system that were broken and need to be fixed. Are you referring to, well, what specifically do you think at this point in time is the most broken and requiring of some sort of remediation, and how are you or will you go about fixing that particular area? And you will both have an opportunity to answer that question as well.
That's a pretty broad question, but probably what I've been working on for the last 6 years, we've made improvements, but it's not there yet, which is treating the family division as a real division of the district court. All the rules of the district court apply. The rules of civil procedure apply. The rules of evidence apply. Unfortunately, historically, that has not been enforced in the family division, and it has brought the respect for the court down and has impaired the administration of justice. Since I've been there, I've been a rule enforcer, and I think that it increases consistency, and it is better at bringing the decisions to the decisions required by the law, and requiring the attorneys to actually do the job that the public is spending thousands of dollars hiring them to do, not just come in and throw spaghetti at the wall, but actually do their research, do their discovery, prepare their cases, apply the relevant facts. Don't keep throwing up a bunch of emotional, irrelevant facts. If you're getting a divorce, unless there's a waste claim, it really doesn't matter if someone had an affair. Yeah, probably 80% of the motions that I see, they throw that in. And some lawyers will spend pages talking about an affair that's completely irrelevant. So you need to force them. Judges have to hold the lawyers accountable, and it's unpleasant when you have to sanction or criticize a lawyer in front of their client, but that's the only way you change the system.
Okay. Romeo, you're in the trenches. What do you see as the biggest problem that needs fixing?
I think one of the biggest problems is consistency among the departments. I think when you have 20 family court judges and you have to ask your client, well, it depends on what judge we're in front of to know what we're going to get, I think that's a problem. I think that the judges have to have some consistency. It is so, I just don't understand why we don't have one 8th Judicial District holiday schedule. Every department has their own holiday schedule, and as far as I know, we all have the same holidays. So I'm not sure why we have to call the department or get online to pull the department's holiday schedule up. There should be some consistency among the departments, and if that means that the judges all get to sit down together and say, this is what we're going to do in most of these cases, then that's what needs to happen. The problem with family court, and Judge Pollock kind of talked about it, is that these are families. It's not money, it's not crime, it's not injuries, it's families, it's children, it's people who've built businesses that now have to divide them. It's people who are losing houses, have lost their houses, have lost their jobs. It's people who have had their hearts torn out because of an affair. It's because of girlfriends. It's because of it's alienating a child from another parent. These are all, I mean, when we get to people in family court, these people are not necessarily rational people. They are thinking on their emotions. This is not a money situation or an injury or damage situation. It's about people. And that's what we need to fix. And I think if you could have some consistency among the departments, instead of always having to say, well, if you've got this judge, we're going to do this. This is what this judge is going to do. If only we drew on that judge. That's not fair to our litigants. And it's not fair to our Clark County.
Okay. And Rena, you've had 2.5-ish decades dealing with all this fun.
Sounds long.
I know, it makes me feel old.
Well, it should make you feel wise.
I do feel wise beyond my years.
So what do you think needs the most improvement?
I think it's not civil procedure. I don't see a judge you know, sliding on civil procedure. It's not attorney's fees. I mean, that doesn't give us enough credit. It's those people who are not represented. Over 60% of the litigants don't have attorneys. And these people don't know the legal process, they don't know their legal rights, they don't know the law, and they're struggling to get through the system. We, of course, need to reach out to those people, and I am on the Outsourced Mediation Committee. We've tried to get rules passed that make mediation more available to these people in their property issues. Right now we have mandatory mediation for child custody. They go through Family Mediation Center, and that's wonderful. But then what do they do when it's mostly lack of assets, it's more debt than anything? What do they do about this house that's upside down? How do they divide their pension plan? They don't know how to do these things. And I do volunteer for Ask a Lawyer, and I do pro bono work, but I think that there needs to be more access to mediation. We have the UNLV mediation program, and fortunately it's staffed by law students, and I had a client go through that one time. It was disastrous. So we need trained people who are willing to either donate their time like I do, or maybe charge on a sliding scale, so we can help these people get through the system and not bog everything down and get them through successfully, because I think settlement and mediation are what people should be striving for, and not fighting, not litigating, because nobody wins then. I think it's very important for them to resolve their cases, and they can't do that without some legal knowledge and some input by a trained mediator.
Perfect. Well, we're right at our 30-minute time.